I'm gonna do is pull up my slides because I did have some slides for this to kind of guide us through this conversation. And what I would like for you to do as you are, kind of getting into the information, please just take a moment and let me know what. Oh, I'm so sorry, y'all. I'm having all kinds of technical things today, but we're gonna figure this out. I appreciate y'all for being my guinea pigs today, as I figure this out. All right, so again, my name is Attorney Veronica McClendon, and I'm presenting this Heirs Property Masterclass live for y'all today. We are going to talk first about, when we get into this, we're going to talk about what is Heirs Property. But I just wanted to first introduce myself and my firm. So I am the owner and CEO of McClendon Law and Consulting. We provide heirs property, estate planning, and probate legal services to help farmers, landowners, and homeowners protect their wealth, increase their income, and secure their legacy. So, what we do is help our clients to create intentional estate planning, succession planning. The goal is to help them manage and transition their assets upon their incapacity or their death. We want to provide families of our clients with guidance to ensure that the estate administration process is smooth. And we also want to help families to transition unproductive property to income producing assets so that they can leave more to their loved ones. One thing that is kind of becoming clear to me over these past few weeks is we all kind of get to the end of the year and we start reflecting on the previous year and thinking about what we want to do for the following year. And one thing I want to do more of is educating people about heirs property, about estate planning. I want to help people to understand more about just ways that you can create an intentional legacy. I'm in a coaching program, and one of my coaches that was presenting this morning asked us the question of what do we want to accomplish in our lives before we die? And I think that that's a question that a lot of people tend to avoid. But really, that's a question that everything is all about. It's all about us thinking, I have a certain amount of time here on earth. I don't know if it's going to be 5 more years, 5 more minutes, or if I'm going to have 50 more years. We don't know how long we have here on this earth. But what we do know is that we have right now. And so my purpose as an individual and my firm's purpose is to help families to be more intentional about the legacies that they're creating and the legacies that they leave for their loved ones. And so that's what we are here today. Regardless of all the stuff that I have on my slides, the main thing that we're here to do today is talk about how can we leave more intentional legacy. So I always like to start with why. If you've attended any of my presentations in the past, you will know that my ultimate goal is to get people thinking about why are they doing this? Why is this something that you are even invested any kind of thought energy into? And we're talking about heirs property today because, like I mentioned, this is an heirs property masterclass. So for those of you who own heirs property, the question is, why do you want to do anything about your heirs property? Why are you taking out the time to participate in this webinar to learn about heirs property? Why is your family property even important to you? I want y'all to think about this as we go into the information we're talking about today, because without a why, there's really no reason to be even participating in this workshop. So let's keep on going and let's talk about why we are doing anything about our family heirs property. What is our why behind it? For many people, they're like, hey, I have an asset and I want to be able to cash in on that asset. I want to be able to sell my family's property as quickly as possible and see what amount of money I can get from the sale of that property. And if that's you, there is no judgment. That is perfectly within your right to do. But if that's what you want to do, it's very important that you know that that's your why from the beginning. If you want to preserve the property for future generations, that may be another why for you. Others may want to honor their ancestors. For some, you might say, hey, I have land. I know God ain't making no more land, and I want to make sure that my family always has a place to stay. If they decide that wherever they are does not work for them anymore, I want them to have a place that they can call home and come back to live if they ever needed it in the future. Some people want to use their family land as a recreational property. That property can be used for the family, just for your personal enjoyment, going and fishing on a pond that you may have, staying in a cabin on the property, or you may decide that you want to rent your family property out. It might be that you have timberland that you want to rent it out to a hunting club. Whatever your why is, creating long-term stream of income. That's another one that people have. And as you can see, looking at this list, the amount of reasons that a person may have for wanting to do something about their family's heirs property can be very different. And what you decide is going to be your reason is going to shape how you approach the task of clearing the title to your heirs property, or whether or not you even decide to do anything about your family heirs property. If your goal is to get a large lump sum of money by selling the property and you realize that you own like 1% of the family property ownership and that property is worth $100,000, you may determine that it's just not worth their while to invest the time and the energy and the resources into seizing that small fractional percentage of fractional interest, or that small percentage of the share of the final pot after it's all said and done. So knowing why you're going about this can also help you decide if it's even worth it for you. So I would love to hear from those of you who are here tuning in live. If you wouldn't mind just sharing in the comments what your why is. What are some of the reasons why you're even remotely interested in your family's heirs property? Why are you here on this webinar? What is it that you're trying to accomplish or hoping to accomplish by doing something about your family heirs property? So now that we talked about why, I know some of you, probably not most of you, because if you tuned in, you had some kind of a clue, but a lot of you might be saying, okay, she asked me, why do I want to deal with my heirs property, but I don't even know what heirs property is. So that's what we're going to talk about now. What is heirs property? Heirs property is a home or land that's passed down from one generation to the next, so that multiple members of the same family become owners of the same property, co-owners of the same property. So this is something that can happen if someone died owning property and they had a will and they said, I want all of my land to go to my 5 children. They've essentially created heirs property. Or if somebody died without a will, without a trust, and that property is just going to whoever their heirs maybe at that time. So let's say they died, and here we have an example here, this visual. You have your original owner. They had 3 children at some point in their lives, but at the time of their death, 2 of their children already were deceased. So the original owner died. They already had 2 children who were deceased. And so what they were left with at the time of their death was 1 child, and then they had the spouse of one of their children, plus two grandchildren from that first child. In addition, they have this 1 grandchild from the 3rd child who passed away. So in this case, you have 1 owner of property, and at the time of their death, that 1 single ownership turned to having 5 people owning the same piece of property. And the thing about that makes heirs property so challenging in many cases, particularly when someone has died without a will or without a trust, there's no documented transfer of the ownership. Someone owned property, the last deed to the property is in their name. You go on any records that you can find concerning the property, it names that person, but unfortunately they're deceased. So we know they don't own the property anymore, but the question is, who owns it? When you have heirs property, that question is not often easily answered. And as you can imagine, the number of people who own the property grows with each generation. So this is an example of how it grows over time. And I did want to just read the comment that someone just said that they believe that heirs property is a key to unlocking generational wealth. And I believe that as well. And that's why I am so passionate about this topic. I believe that heirs property is a key to unlocking generational wealth. I also believe that heirs property is a key to unlocking just a better understanding of who you are as an individual. I think a lot of us don't realize how much being connected to our history, to our family land, to other things in our lives that may help us to remember where we come from. That helps us to understand more about who we are and where we're going. So I think heirs property has so much potential. And if we help people to get access to their family property, I believe there's going to have a lot of different impacts that we can't even imagine today. But like I mentioned before, we started with we started with 5 people who owned this property. And now, as generations have gone on, we have now a far greater number of people who now own an interest in this family property. So, it's the typical thing. All the children at this point are deceased. All the children of the original owner are deceased. The spouse of the first child has now died as well, and now we just have their 2 children here. The one of the grandchildren have died, and so we have some great grandchildren in the midst here, and we also have here the mother of one of the great grandchildren. She is not married into the family. She is just a mother of one of the original owner's great grandchildren. And you may wonder, how could this happen? Well, let's go through this little chart here. So we had the original owner at the time of their death. Child number 2 was still living. So that means that whatever that one, let me rephrase this. So at the time of original owner's death, they had, in the past, they had 3 children. So their interest in the property went from 1 share of ownership to being split between 3 shares of ownership, one for each branch of their family that comes from their children. Child number 2's branch, at the time of their death, it went to a grandchild here, and then it went to another grandchild here, and another grandchild here. Grandchild 2C, which is the second child of child number 2, at the time of their death, they had 2 children. So that means those were the great grandchildren of the original owner. Unfortunately, one of the great grandchildren died. They were not married. They did not have children. So their interest in the property now goes to their surviving mother. So grandchild 2C here had died already. And so the father is already deceased. And all we have left is the mother of this great grandchild, who now has inherited an interest in this family property. This could be a house, it could be land, it's family property. And now we have someone who's not a blood relative who has inherited an interest in the property. And you can imagine how crazy this can get. Let's say that mother of great grandchild 2C2 remarried. Let's say that she got married again, and she and her spouse, they had some more children. Then this woman has died, and her surviving spouse and her surviving children now inherited what she inherited from her oldest child, who died when they were still a child. So you can just imagine how crazy this gets, because now you have not only one woman who was not blood related to the original owner, but now you have her second spouse and the children that came from that marriage, who are now have an ownership interest in this family property. We may not even know who those people are, but this is the kind of situation that we often find ourselves in when we're dealing with heirs property. So is that crazy for y'all? If anybody thinks that that's a crazy scenario, I love to hear about it in the comments. It's one of those situations where I tell families we don't know what we're going to find until we actually start digging in here. And that's one of the reasons why. So when you're dealing with heirs property, there are a lot of challenges. Some of those challenges include the fact that all of the co-owners have equal rights to use the entire property. So you can't say, no, you only have a 1% interest. You only can use 1% of the property. It's like, no. All of the people, regardless of how much ownership they actually inherited, they have full access to the property. Any of those co-owners have the right to sell their interest in the property to someone outside the family. Here in Georgia, that used to be a huge, huge issue. because that means that that person who they sold it to outside the family could then force a sale of the property and be able to either cash in or have their buddy to buy the house, buy the property, or whatever it may be. And I said that used to be an issue before. And the reason why I said it used to be a big issue before is because we had a law passed called the Uniform Partition of Heirs Property Act, which made it harder for outsiders to take advantage of taking a small interest in the property and forcing a sale of it. However, as I was saying that, I remember the case that I have, and I do remember that this can, even with this new law, it causes a lot of problems for families, because what often happens with heirs property is that the property value can increase quite significantly. And there are rights for the other family members to buy out this outsider who has purchased a part of the property, but the purchase price could be very high. So that's a big issue still, that co-owners of this family property could sell the interest to someone outside the family. And I do also want to say, if there's anything that I'm saying is not clear, be sure to put it in the comments so that I can address it and make sure that I'm being clear as I speak about this. Another issue with heirs property is that certain actions concerning the property are going to require the agreement of all of the co-owners. So that means if you want to sell the property, if you want to sell timber from the property, if you want to borrow money against the property, or you want to participate in weatherization or roof repair programs that might be offered by your local government. There also are programs that are for farmers that the local government or the federal government may offer programs and incentives to help those farmers. Well, those are things that you would not be able to take advantage of unless you have 100% agreement from all of the owners. And if anybody has dealt with any family before, you know that getting all of the family to agree to what we're going to have for Christmas dinner is hard enough. So getting everybody to agree on who we're going to sell the timber to and how much we're going to agree to it, and even just finding everybody so that you can get them to sign the papers, that's hard. So these are issues that come up. The property can become subject to the debts of co-owners. Everybody's not going to do their part, and families end up losing generational wealth, all because of heirs property. So these are all issues that come up. My clients deal with these things all the time, and I don't always have a out the box answer or solution for them, because I tell people heirs property could have taken 50, 100 years to be created. So what makes you think we're going to fix it in 6 months? I'm hoping it don't take 100 years, but let's not. 6 months is a little unreasonable considering how long and how deep these heirs property issues can get. So families often lose their family property when it's heirs property. A lot of that happens. I think number one reason is unpaid property taxes. You know, if you have land or even real houses in like an urban area that is very high value property, and that property ends up, you know, the taxes get high, and every year you got to get everybody on board to pay the taxes, and you got to get everybody on board year after year after year. Eventually people get tired and they say, I don't want to deal with this anymore. So you're going to have to figure out a way to pay it yourself. And a lot of times families will end up losing the property because they feel like, I'm throwing my money in the trash can by paying these property taxes, and I can't even use this property. A lot of times when you're dealing with homes and someone has died and their property becomes family property, families end up losing the property due to a mortgage or reverse mortgage foreclosure. Because there'll be this mortgage on the property. Somebody might know about it and be like, well, I know mama always paid $500 a month. And we know that probably does not happen, but maybe mama always paid $1,000 a month on this mortgage. And now here we are where the mortgage payment has increased because the escrow account went low. And so they increased the amount of the mortgage payment so we can pay the escrow, fill the escrow account back up. Those kind of things would not necessarily be communicated to the family members. And so they're still paying that same $1,000 a month. And then next thing you know, they're getting notice that the property is being foreclosed, and they can't even get the bank to talk to them because they say your name is not on the property. If y'all know anybody who has dealt with that, I would love to hear about it. Put it in the comments, the chat, so that we can, just kind of know more. But do not put your personal information in there. Don't say, yeah, my mama, she lived at 123 Happy Lane and this. No, don't do that. But if you want to share information with others about your own experience, that helps us all to kind of see that none of us are alone. A lot of times family members don't update insurance after someone has died. They might still be paying a premium, but the insurance is in the name of a deceased person. And it's up to the insurance company to decide if they're going to honor that insurance contract, because the contract is between them and the person who's now deceased. So they don't have obligations to everybody just because they're a member of the family. They have obligations to the person who entered that insurance policy with them. So a lot of times families will not be able to get the insurance to pay a claim, to pay for repairs or things that may have happened. Let's say that the roof got messed up and insurance gets called and says, hey, we need you to cover the repair of this roof. Insurance company says, are you John Doe? And say, no, John Doe, he died 5 years ago, but we've been paying the premiums. And they're like, well, we cover John Doe. I don't know about y'all, but we ain't covering y'all. So then family ends up not getting the repairs done and the property falls into disrepair. And then another way, families have disputes. They don't want to all do the same thing. They don't think it's fair that Susie get to live in the house and she ain't paying no rent and all those different things that happen. Next thing you know, the family ends up losing that property. Because this it's like this is like crazy. I think a lot of people just don't realize like how vulnerable family property can be. There's so many cases. I know people say, well, this it's just a family house. We just never did anything legally with the property because it's the family house and we want it to always be the family house. But they don't realize that you have all of these different people's names on the title to the property now. And then that has its own issues. And as I say that, I realize that I use the term title very frequently. And title is something that is not a word that everybody knows what it means. So what I'm going to do is talk about title, and I'm going to talk about deed. A title is the fact that you have ownership of property. You can have record title, which means that your ownership is documented in a deed or in some kind of an affidavit. Or you can just have what I call actual title. There may be another word. I think it might even be like beneficial title or equitable title or something. There's other words, but I say actual title, which means that you have inherited an interest in this property. There's no documentation to show it happened, but you know that your mama owned it. So now that she's gone, of course you own at least a part of it. So that's what I call actual title. Like I said, that's probably not the legal term, but you actually own an interest in this property. There's just no documentation. So a lot of times families don't realize that when someone dies, you may look and say, well, grandma's name is still on the deed. Grandma's name is still on the taxes. But since grandma is deceased, her ownership has now been transferred to her heirs. Or if she had a will, go through the will. But we're not talking about people with wills because we're talking about undocumented transfers. So people who died without a will, it goes to their heirs automatically by law. How that happens is going to be determined by your state law. But here in the state of Georgia, if someone dies, they don't have a will. If they have a spouse, no children, everything goes to their spouse. Even if they own family property, their interest in family property goes to that spouse. If they have a spouse and children, it's going to be split between the spouse and the children. If they don't have a spouse, but they have children, the children are going to receive it equally. And that's inside children and outside children. So we're not counting people out just because they weren't born into a marriage. We're talking about all the children of this person. And there's a lot of details to that I won't get into today, but let's not count people out just because they were born outside the marriage. You also have, if someone has died, they don't have children at the time of their death, then we're going to be looking at your parents. If your parents are deceased, we're looking at brothers and sisters. If brothers and sisters are deceased, then we're looking at nieces and nephews. And it just goes on and on and on and on until we get to someone who doesn't have any kind of blood relatives, which is very, very, very unlikely. They will find your fourth cousin if they can be found. But let's say we can't find your fourth cousin, then it will go to the state. And I want to be clear, these states. So it goes to the state. So whatever state you lived in at the time of your death. But that's a long path to get into the state. There are a lot of other people who could possibly inherit an interest in your property at the time of your death if you do not have any kind of will or trust in place. We will talk about why it's important to have a will or a trust in place, but we're just assuming that people are dying without them because that's what happens a lot with heirs property. So we've talked about a lot of the problems with heirs property. I want to know, did you learn anything that was surprising to you? If you just do me a favor and just let me know, I didn't realize this. I would love to know that. As we go into now, resolving heirs property, I want to say this. I don't have, and I told y'all this already, I don't have like a out the box solution. This is how we're going to solve your heirs property. Because solving heirs property is something that is going to be a family by family type situation. I don't know how many brothers and sisters we're talking about, how many children your original owner had, and I don't know if people got married and remarried and had children who died. Like, I don't know any of that stuff. So whenever I'm working with the family to help them to get clear ownership of their family property or resolve their heirs property, one thing I want y'all to know is that every family is going to have a different solution depending on their family circumstances. Another thing I want you to know is that the resolution process can vary because it's going to depend on how many people we know and how many people we don't know. It's going to depend on if people's addresses and information can be found and if it can't be found. It's going to depend on if they want to be found. You might have the information and you might reach out to them and they don't respond. That's going to impact the timeline. We also have situations where people just take their time. They willing to help. They say, I'm going to sign the papers, but you send them the papers and then you call them. They say, oh, yeah, I'm going to sign the papers. And then you call them back a month later. They say, oh, yeah, I got to find the papers. Can you send it back to me? And then you send it back to them. And then they say, oh, my dog ate it. Can you send it to me by my email? You just all these things that could happen that would impact how long it takes to resolve your family's heirs property. So what's important is that you go back to your goal and know what your goal is, because your goal is going to impact if you want to go through all that. Another thing I also do, and I have no slides on these because these are things I just started thinking about lately. Another thing that I like to now work with my families on doing is we may not be able to get this all cleaned up within the next year or two, but can we stop the bleeding? Can we put things in place? And I'm going to just pause my share real quick. Can we stop the bleeding? Can we put things in place so that we can at least make sure that things don't continue to get worse? Because as I showed y'all before with that slide, things tend to get worse over time as more and more members of the family die. You even could have family members who become ill. They could get dementia. They could develop dementia. They could become disabled from a stroke or a car accident. You don't know what could happen. And so if you want to stop the problem from getting worse with life happening over time, sometimes we might say, let's create an entity to own the interest in the property, like an LLC or a trust, that if someone were to die, there's rules in place within that entity to show how their interest is going to be handled versus it being subject to state law and inheritance laws and things like that. So there's a lot of things that we might do to try to manage the situation as we're working to clean up the situation. But everybody's path is going to be very different. So I just wanted to do that little caveat there. I had one more thing I was going to say about resolving heirs property. Resolution is going to look different for every family. So I told y'all that the process to getting things resolved can vary from family to family. But the outcome that we go for could vary as well. For example, in order to sell the timber on your family property, you might not have to clean up all of the heirs' property before you can sell the timber. You might be able to get your timber company to agree that if you get an administrator appointed over a particular estate, then that administrator can sell the timber to the timber company. And once they do that, the money from that can be used to help continue cleaning up the title to the property, help pay taxes, things like that. So we don't have a fully clean title at the end of that situation. However, we might be at a place where we can get more money that can help us to get clean title, clear title, or we could get to a point where we can start using the property in a way that we weren't able to use it before, even though the property ownership is not 100% cleaned up. So there are interim strategies. It might be that you are a person who just needs to participate in a home repair program. You've been living in your grandma's house for as long as you can remember, and it's heirs property, but you've been the only one there paying the taxes, living there, maintaining the yard, whatever there might be that needs to happen. And this particular entity you're working with, whether it's a local government or a nonprofit, they might say, hey, if you can deal with ABC, we will allow you to get money to get your roof repaired or to get the siding on your property repaired. Even though you don't have 100% clear ownership, you might be able to do what this organization requires for you to qualify for the assistance that you want. So I just wanted to say that clearing title to heirs property, resolving heirs property does not have to mean 100% clean ownership. Of course, that's what we want in the end, but sometimes your goal may not require that you go through all of that. So I need to add, one of the goals might be that you want to just get your home repaired, or you want to access a farming program. So that's another thing here in Georgia, and with some USDA programs, the United States Department of Agriculture, they have a process that you can follow if your family property is heirs property, so that you can participate in farm programs. You do have to go through a certain process. You have to meet certain requirements, but you don't have to get the property completely cleaned up in order to qualify for those programs. So that's another situation that I wanted to bring up. And we will go and talk about how I like to guide families through cleaning title to heirs property. But I had one more thought that just came. I have to be careful about my words. I'm not always really careful about it, so y'all forgive me. But we also have to think, do we need clear title, which might mean that we know who all of the owners of the property are, and we'll talk about that in a minute. And we can say, this is how much everybody owns. Or you might need to have marketable title, which means it's good enough to sell it. And that there are certain things that can make it good enough to sell, but may not be actually clean, clear title. And then also you have consolidated title, which we'll talk about in a minute, which means that you have a single owner. Some people you deal with, they're not going to want to deal with a lot of different owners. Even if you know who everybody is, they're going to say, I want one person who can sign this paper, no more than two. And so you might have to consolidate the ownership. So that is what we're going to talk about now. And so I do want to address this question. That can you explain what happens to a property in the name of an LLC? What happens to the property if the owner passes? So that is actually going to feed into this next section. And I'll mention that once what did I do? In a minute, y'all. Okay, I need some help. Can y'all see? Did y'all see? Okay, y'all. Did y'all see any of my slides? Please tell me y'all saw my slides. If you didn't my slides, then it's just too bad. Y'all saw my slides? Okay, y'all saw my slides. All right. It's like all this time been talking and clicking and doing this and that. Y'all ain't seen it, but y'all see it. All right, we're back. Resolving heirs property. So let me just go through my slides and show y'all these 4 steps to address heirs property, even though it says 3, because it was 3 and I added another one today and I forgot to update the number. But I like to deal with addressing heirs property in 4 steps. First, we want to clear the title. And I say first, second, third, fourth, but it's not necessarily in this particular order, but we're just going to say first, second, third, fourth. First, we want to clear the title. Second, we want to consolidate the title. Third, we want to consolidate the property to profitable use. And fourth, we want to create an estate or succession plan. And so, like I said, I got these numbers 1, 2, 3, 4. However, a lot of times we kind of go out of order because we're just trying to get closer to a resolution. And sometimes it might take longer to deal with one. So we start working on the second one. Or we might say, hey, I need y'all to all go work on number 3 while the lawyer is working on number 1 and 2. So there are a lot of things that we can do to kind of mix and match so that we can actually get the job done. First, clear title. Clear the title. Like I said, okay, y'all. Pardon me here. As I like go through my slides, I've done this particular presentation like 100 times, but I always find something that I'm like, I just contradicted myself. So I talked about clear title and I talked about marketable title and how they may not be the same thing, but here I go making them look like they're the same thing. They're not. Clear title and marketable title are different. You may not need both. You may only need one. You don't have to worry about that for today. Just know they're 2 different things. But what we're talking about when we're talking about clear-ish title or title that you might be able to sell, let's do that, clear-ish. Title is free from claims or disputes about the ownership. That means we know who owns this property, ain't nobody arguing about it, and we can look at records and say, this is who owns the property. When we look at the county real estate records, the names of the people who own the property are the same as the people who actually own the property. When I say county real estate records, do not equate that to tax records. The tax records that the county has, they got their own system. The real estate records in the Superior Court, that's Georgia. The real estate records may have a different system than the tax system. So they may not say the same thing. A lot of people, they look at the taxes and they say, well, the property's in my name. I say, no, the taxes are in your name. So that means you get the tax bill, but that means these other people still own a part of the property, but you just the one paying the taxes. There's a difference. Heirs property does not have clear title. You have multiple owners who are not shown in the county real estate or tax records. You have incomplete legal work that was not done after original property has died. And then additional research is required to identify who the owners are. And so I want to get to the question that was mentioned in the chat of what happens to a property when the property is in the name of an LLC and when the owner dies. So when we are dealing with property that is in an individual's name and that person dies, the property is going to be inherited by, if they don't have a will or trust, it's going to be inherited by their heirs at law. As I mentioned before, who your heirs at law are is going to be determined by state law. And as those people who were your heirs at the time of your death, after they die, then their individual heirs will also inherit an interest in this family property. All of this happens because the law does not want the property being owned by people who are deceased. They want it being owned by people who are living. Even though we don't have any documentation as to who are the owners, the ownership transfer has happened as a person has died. So keep that in mind, that when you don't have any kind of instrument in place like an LLC or a trust, then it's going to be state law that determines how property is going to be distributed after a particular person dies and they own an interest in this property. So just keep that in mind as we continue on. So we are still on clearing title. When we're working a clear title, we want to deal with title issues one by one. There may be debts that need to be paid out. There may be some statutes of limitations that if you wait them out a little bit, then that'll clean up some of the issues with the family property. We might be able to clean up ownership with affidavits of descent. An affidavit of descent is a document that shows so-and-so was an owner of this property. And so what we usually would connect the affidavit of descent to is one of the most recent deeds to the property. We're going to look at that deed and say, who owned this property? And then we're going to say that person's deceased. And in our affidavit of descent, we're going to state this person owned this property. They died in this county. This is how many years. The person who's writing the affidavit knew this person. And then we're going to say that this person was married to this individual. These are the names of their children. This is generally what we will put on an affidavit of descent to show who inherited an interest in this property, so that it's no longer just, as I say, in the air that someone died and now their heirs on the property. We actually have legal documentation to show who those particular individuals are or were. we also can execute some deeds from that point to get the ownership cleaned up. And I'm saying all this in very general terms. These are not things that anybody should do unless they have a lawyer, because it's really, really convoluted. And I don't say any lawyer. All lawyers are. I love lawyers because I'm a lawyer and I just love lawyers. But if you're a criminal lawyer, please do not do anything real estate related. If you're a family lawyer, do not do anything real estate related. Like the number of lawyers that done messed up real estate titles, I don't know how many there are, but I'm sure it's a lot of stuff from lawyers who were not familiar with real estate, probate, and it's no harm to them. But you ain't gonna find me defending nobody in a criminal case because I don't know it. I'm not gonna be out there fighting white collar crime because I don't know any of that stuff. So I do respectfully ask that just because your cousin is a lawyer, please don't have them drafting no affidavits or no deeds. I had to just get back colloquial on y'all because I'm just trying to get this message out here. If you are not a real estate lawyer, please do not draft a deed. Do not draft an affidavit. I know it looks easy. It looks like fill in the blank, but there's so much that goes beyond the actual form that needs to be thought about. So I would get off my soapbox theory because y'all making me have to deal with all these title issues, but nobody's really making me rich from that because they don't want to pay to clean it up. So please get lawyers to do this stuff that are real estate lawyers or probate lawyers who understand all the stuff that goes into it. If you're clearing the title of the heirs property, it may require one or more out of court or in court legal transactions. We don't know what it's going to be at the beginning. I have to do a full title search, look at your family tree, look at when people died, look at where they died, and all this stuff to determine, are we filing a partition? Oh, also, I'm looking at client goals. It's always going to go back to that why, to those goals. But we're going to decide, are we filing a partition? Are we filing quiet title? Are we going to probate one estate or are we going to probate 10 estates? Are we going to do some deed transfers? Are we going to record some deeds that maybe were already signed, but nobody actually filed it in the courthouse? Or we're going to do all of the above. I don't know until I actually dig in deep into it. And that's why I say it's so important that you work with a lawyer who understands all these dynamics, because it's really like, I don't know, I was going to say like playing chess, but I don't know how to play chess. But I do know how to deal with real estate and heirs property situations. So, all right. So we talked about clearing the title. What we end up with when we clear the title, we end up with documentation of who are the individual people who have inherited an interest of this property. We'll know how much of an interest each of them owns, at least to the best of our ability. We may not get 100% there, but we may get 80% there. We may get 95% there. We don't know. We just get as far as we can. Once we get as far as we can, we want to consolidate the title. And as I mentioned, this could happen before clearing title, because we might say, we don't know all of the people, but we're going to start by doing something like creating an LLC, as was mentioned before. Or we might create a trust. Or we might identify one member of the family that we want to have 100% ownership of this property. But whatever we decided would be our end goal, we might already start the process of transferring ownership to that entity so that we don't continue to have the issues of people dying and the property continuing to be split between all these different people. So to answer the question that was in the chat more directly now, the question again was, can you explain what happens to property that's in the name of an LLC if the property, and what happens to the property if the owner passes? So we talked about if the property is in the names of individuals, as each individual dies, their interest in the property, whether it's 100%, 50%, 10%, whatever it is they've inherited from the original owner, that is going to be passed to their heirs as they die. And that just goes on and on and on and on till someone stops to bleed. One way that we can stop the bleed is by creating a limited liability company or an LLC. And what we do is create an LLC. We register it with the Secretary of State. That's how we do it in Georgia. It's similar in other states. But we also would create an operating agreement. That operating agreement explains what happens when someone who's part of this LLC dies. So typically what would happen is that let me see, I'm kind of getting ahead of myself. Let me pull it back a little bit. So one of the ways that we might take the ownership from all of those individual family members who inherited an interest, we might get all of them to agree that they want to form an LLC and that we want to have each of them to sign a deed to transfer their interest in the property from their name as an individual into the LLC. So let's say that we had 50 people in the family who all inherited a portion of ownership in this property. If we can get all 50 of those people to agree that they will deed their interest in the property into the LLC, that ownership goes from being owned by 50 people to being owned by one single LLC. And we would have an operating agreement that goes with the LLC that says if any of the members of this LLC were to die, any of the people who have transferred their ownership interest into the LLC and agreed to continue to participate in the LLC as a member, if any of the members die, then this is what's going to happen to their interest in the property. The property will always be owned by this one LLC, but the members of the LLC will own an interest, or more easily to be said, a share in the LLC. So their share might get passed to whoever their heirs are, but the property is going to still be owned by one person. And if you have a strong operating agreement, you will have rules in place that ensures that there's always one or a group of people who are going to be making decisions for this property, who are going to manage it, make sure that it has everything it needs to be sustainable. That group of people will be there. You'll have rules in place for if one of them dies, who's going to replace them, how will decisions continue to be made for this LLC. But the ownership of the property is not going to be impacted as family members die, because the property is going to still be owned by that LLC. So I hope that answers that question. If it doesn't, please ask a clarifying question in the chat. But the same can go if you create a trust and put the property into a trust. Same thing can happen if you create a corporation, you transfer ownership to the corporation. Some people might create a nonprofit and they transfer ownership of the property to a nonprofit. What you're doing there is creating a legal entity that does not have flesh and blood. It does not die because it got sick or it got really old or it got into a car accident. That entity will remain as long as the people who are running it have an intent for it to continue to remain. There are other entities, legal entities you might create. We won't go into details there, but that's a way that you consolidate the interest from a lot of owners to a single owner. Sometimes families will say, like I have one client who is a farmer. He wants to continue the farming legacy in the family. Most of the family has moved up north. They have no interest in farming. So they all agreed, which is beautiful. There was a lot of people that we had to get to sign deeds to this one person, but most of them agreed to do it for free. Some agreed for a small fee, but we got it to where this family agreed to transfer ownership from all of these family members to this one person who is a farmer. And what we doing with this farmer, we're gonna make sure that they have an LLC to transfer the property into, and that they have an estate plan, a will, or a trust, so that if something happens to them, we don't end up with it being heirs property again. But what we're doing is taking ownership from all those people who got to agree on everything to put them under a single ownership umbrella. So clearing title, consolidating title. This is create a succession plan. I kind of got my slides out of order, but creating a succession plan, we're preventing the property from becoming heirs property again. We want to promote the seamless transition of the property from one generation to the next by having clear instructions in place. We want to educate each family member on the importance of estate planning, because you have this family entity that you may have created, and you may have put rules in place that if someone dies, this is how their membership interest is going to be transferred. But when I do those entities, I always put a provision in place to say if someone has a will or a trust and they say, I want my interest in this LLC to pass to these particular individuals, we put provisions in place to allow that. So let's think of an example where someone is a key member of this LLC. They own 1/4 of an interest in the LLC. However, they don't have a spouse. Well, most of my clients, they don't want spouses included. They love the spouses for the most part, but they don't want them in the LLC. They want it to be blood family. So if this person did not have any blood children, then what the operating agreement would typically say is that their interest will now be split between all of their brothers and sisters, or it would be split between nieces and nephews. But if that person wants to say, I wanted to go to this one nephew or this one niece, then they get to put that in their estate plan and direct their ownership of the LLC to go to particular individuals rather than it just going to all of their heirs, whoever they may be at that time. So we want to make sure that all of the family members, even though we may have a family LLC, that each of the family members also creates an estate plan of their own so that their part of the LLC is going to the person that they want it to go to. And so we're also not only transferring land assets or property assets, we're also transferring the knowledge, transferring family history, we're transferring the history of the property. We want to make sure that the family knows, okay, from here on out, this is how we document and who are the members of this family, who's going to participate in this family property. But we're also going to make sure everybody knows how great grandmama ended up with this property and all the work that she had to do to maintain it, all of the stress that she had to endure in order to ensure this property is here for us. So you want to transfer those things as well. Here, I just wanted to reiterate again, we need to make sure that while we're clearing the title of the heirs property, that we got someone paying the taxes. We're maintaining our tax exemption so that we are paying is the amount of tax that's appropriate for the type of property that we're dealing with. We want to keep our homeowners insurance up to date and property insurance up to date. And we want to keep our property record, our property maintained and up to code standards. Finally, we want to set aside money for repairs, emergencies, legal fees, and all of the things that go into clearing title to heirs property. You want to have the family to create a plan for how that's going to happen so that nobody's caught off guard. And I think, okay, I left off my slide of putting property to profitable use, but I wanted to do a little mention on that because what's so important with families is that they actually have, again, a reason, a why behind why they're doing all this. Because you can do all this work, spend all this money. If you don't know what your why is, then like, what's the point? And sometimes the problem is that we can actually make money from this property, that it can be a source of wealth, either to us individually or collectively, can be a why that family members will get on board with, that they'll feel is something that is worth them invested into because they know they'll get a return in the future. So I always encourage families, when you have heirs property, put it to profitable use. Don't let that property just sit around and just, oh, it's just a family legacy. It's just something that we want to keep to honor our grandparents, but you don't go and you don't maintain it. You don't do anything to make sure the taxes are paid. We want this to be something that future generations value. They may not have that sentimental feeling that you get when you visit a property because you remember milking cows on the property. You remember the sleepovers y'all used to have. You remember when y'all used to go hunting or go hiking in the woods. You remember all that. But the future generations, they may not remember that. So you want to make sure that this property still has value for them. And sometimes that's going to come from putting it to profitable use. Even if you just put in something that allows them to be able to pay the taxes without having to come out of their pocket, that can be a start. But put it in some kind of use. Sometimes people will work with a nonprofit where they can grow trees on the property and then it allows them to sell carbon credits to corporations who need to offset their pollution. And so they might be able to get money from these companies that can be used to help pay taxes and maintain the property. There are programs like that out there. And if you're interested in any of them, let me know and I can point you in the direction of resources that I'm aware of. There are conservation easements out there where if you know that you want to keep your property in agricultural use, you can do that. And then this nonprofit will actually pay you to ensure that that happens for into perpetuity, as they say. So forever. So, forever, forever, ever, forever, ever. We don't know what forever means, but in theory, it's forever. So you can put your program, your land in a program like that, so that the family gets some money that they can use for whatever they need to use it for, but it's going to always be maintained as an agricultural property. There are things you could do with real estate inside the cities, like you can do like historical preservation. There might be some tax credits there. There's all kinds of opportunities that are available that can help the family to have a financial why behind their family heirs property. So I'm going to pretty much end there in terms of the content that I had. I'm going to move forward to the slide where I talk about how you can get in touch with me if you are interested. We're going to have a part 2, a part 3, a part 10, because this conversation goes on and on and on and on. So here we go again with my little thing. So if y'all are interested in connecting with our firm, you can scan this QR code. I actually forgot to see where this QR code goes. It might put you on my email list. Just scan it and then you can see where it leads you. And if you want to put your information in there, you can do it. If not, here's our contact information where you can reach out to us. So this is the end of the teaching part. I am going to stop the YouTube stream so that we can have time for question and answer. If you want to, once I stop the live stream, I will let y'all know, and you can unmute yourself, raise your hand, whatever you need to do. If you have a question, you can put a question in the chat, whatever you'd like to do. But I hope that this was helpful to y'all, that it was something that helps you to be to get further along on your journey. I also will be doing another webinar very soon. I'll let y'all know the date if you find a QR code and put your information there, or just let us know that you're interested. You can put it in the chat. I will do another webinar. So if you know there's something you want me to cover, please let me know so that I can make sure that I cover it in the next webinar. Because I want these to be useful to everyone who attends. So I am going to go ahead and stop my share.